Welcome everyone to Real Talk Divorce San Diego. My name's Lynn Waldman. I am a therapist and divorce coach, and I would like to introduce you to my co-host, Shawn Skillin, a family law attorney, and Mark Hill, a certified divorce financial expert. And today we have several topics we're looking forward to talking to you about. Our divorce options workshop. We want to discuss the new spousal support tax law, and we also want to talk to you about collaborative divorce. So our first topic, divorce options, is a once-a-month workshop, the first Saturday of every month from 9 to noon in Carmel Valley, and it is presented by a divorce coach, an attorney, and a divorce financial expert. So Shawn, please tell us who should attend the divorce options workshop.
Well, anyone who is thinking about considering divorce or legal separation, unmarried parents who share children who are maybe splitting up and trying to develop a parenting plan, and talking about support. So anybody who's already in the process of divorce, but they're dissatisfied with the way it's going and the process that they're involved in so far, those people are all appropriate to attend.
And what do you usually talk about at Divorce Options as far as an attorney and your role as an attorney at Divorce Options?
Well, Divorce Options kind of crosses a broad range of topics, and I know you're going to discuss what you talk about. Mark will talk what he talks about. But generally, we always say that the most important decision you have to make after deciding to get divorced is how you want to get divorced. And so we'll talk about the different options that you have to consider in that, because that is a very important decision moving forward. We'll talk a little bit about specific legal things like date of separation, does it matter? We'll talk about the court process, the paperwork that you need to file, how long it takes to get through all those processes at the court, which the answer to that is a long time nowadays. But we'll talk about a whole bunch of stuff like that.
So you cover the do-it-yourself option.
We talk about doing it yourself. We talk about going through a mediation process, a collaborative divorce process, and of course the traditional thing that most people think about is litigation, where you each get an attorney and go to court.
And Mark, from the financial perspective, what kind of things do you cover at Divorce Options?
We really go into quite a great deal of depth in terms of all of the financial aspects of divorce. For most people, a divorce will be the largest financial transaction of their life. And so we try to essentially give people an understanding of what the issues are and what they'll need to address from the financial standpoint, and also try to get them to consider not just trying to get what is they would perhaps consider a fair settlement, but also understand what the impact of that settlement is going to be 5, 10, 15 years down the road.
And I know oftentimes clients will say, where do I start when they're thinking about divorce? So Divorce Options then is a great place.
Divorce Options would be a great place to start. I mean, some people say, should I talk to my financial person? Should I talk to my therapist about how we tell the kids? Should I go talk to a lawyer about my legal rights? And of course, in Divorce Options, you have all three of those people present at the same time, covering all those kind of topics. And Lynn, you presented Divorce Options a lot of times as one of the mental health professional and a divorce coach. What is it that you usually like to highlight in Divorce Options?
Well, what's important for us is, because as you guys both are saying, divorce is legal, it's financial, and sometimes the emotional impact gets kind of lost in that. So, and that's what can really sidetrack a divorce. So what we focus on is managing emotions, communication. We want to support our clients in being able to negotiate and to be able to negotiate with their spouse across the table. And also child sharing can be huge for couples, of course, with kids. They've never had to think about those kind of things before. When will the children spend time with mom? When will they spend time with dad? And what will that look like? So we help them with those aspects as well.
Yeah, I mean, I think that people always do give short shrift to the emotional impact it has. They think about how their kids are going to be affected by divorce, which of course is very important to anyone who's a parent. But I think sometimes they underestimate the importance of the emotional impact that it's going to have on them. And I think that the people that have attended Divorce Options in the last couple of years always talk about how helpful it is to hear you talk about the emotional impact and how they can manage some of those emotions, and the tips and the tricks that you give them from that standpoint. And I know as an attorney, people that have had that kind of coaching, it certainly helps me get them through the legal, official paperwork part and some of the decision making when they've had a coach to help them with the emotional stuff.
Yes, and what I like about Divorce Options, and you guys may agree, is that it's really an unbiased presentation, because as you said, after you decide to divorce, one of the most important questions is how. And so I think that's what we do in Divorce Options, is it's an unbiased explanation of the different ways that people could choose to get divorced.
Yeah, it's very much a decision that tends to get overlooked. And it's funny, you were saying that people tend to be giving short shrift to the emotional aspects when they are usually bundles of emotion when they come in. Usually fear or anger is what you tend to see. And to get someone to slow down, and as opposed to going out and getting the most aggressive attorney they can to support them, and that may be an option they have to go to down the road, but instead of doing that right off the bat, if someone can step back, take a deep breath, understand what the consequences of the decision they're going to make about how they divorce and how that will impact their future, their relationship with their soon-to-be ex-spouse. If there are children, you're going to have a relationship with this person really for as long as you are alive. If you're fortunate, there will be grandchildren. And you want to be able to go to graduations and weddings and not be in a situation where you're still fighting because the way the divorce came out was unsatisfactory to one or both of you.
Yes, and when both people are feeling wounded or that it was unjust for both of them, that's not a good outcome. And our hope is for families to be able to, while their family is different and it's changed and morphed or formed into something else, that they're still able to have those relationships.
As you guys may know, I had a divorce that went all the way to trial. It's what spurred me back in the 90s to start doing this work. I walked out of there using these words: I have been violated by this process. My lawyer apologized to me. Later, because my wife and I had no children, we just had a house to sell, we got together, and I was shocked to find out that she felt the same way. Later, I actually trained her attorney in collaborative, and he said what an awful case that was. So it's not always satisfactory to the professionals as well as to the participants. And so this is something that if there's any professionals out there watching, you may want to consider becoming involved in.
Yes.
So Lynn, we have a live question.
We have a question,
yes. And it's for you. Carol would like to know if you can explain the difference between a divorce coach and therapy. And that's a great question, Carol. We hear that all the time.
That is a great question. And divorce coaching in a collaborative divorce is teaching people new skills they might not have had before. How to communicate, how to be able to tolerate distress of the divorce, regulate their emotions. And one really important skill that I love to teach people is what we call interpersonal effectiveness. It's just basically, how can I say what I need to say in a way that the other person will hear me? And that's much different than therapy, because therapy, we're looking at your history and trauma that you may have suffered, and we're debriefing that trauma and looking at how you want to recover and have a different future. And while you might still be learning skills in therapy, divorce coaching is in this moment, how can I negotiate and get along better with my soon-to-be ex-spouse?
Great.
So, shall we move on to the new tax laws? Because I know that's confusing for some people and a little bit scary and overwhelming. So, Mark, can you tell us what's happening with the new tax laws on spousal support?
Yes, well, the traditional way that we've handled this over the years, which enabled us to get the IRS to assist with paying for a sum of the divorce, is going away at the end of this year. So critically, if you've not filed for divorce by June 30th, because of the 6-month wait in California, and I know there's some things around legal separations that we can do, but just to keep it simple, you must file by June 30th. You must complete the divorce by year end, have an agreement in place and have it filed with the court, and then the payment by the payor spouse is deductible, tax deductible at their rate, usually the higher earner that pays at a higher rate, and taxable to the receiving spouse. And so you're able to sort of shift brackets. That is going away this year, so we will no longer be able to do that. That's creating some situations that will make divorce more difficult to achieve, in my opinion. And it's also creating a huge logjam of people who want to get this through this year and keep that benefit.
Now, does their divorce have to be final by this year, or do they just have to file by this year to get that benefit?
I don't know that that's actually been resolved, has it, Shawn?
Yeah, there's two schools of thought. So the tax deductibility of spousal support has always had a number of requirements that had to be met to satisfy the IRS for it to be deductible. And that language hasn't necessarily changed. It says that you have to be living apart, and there has to be some kind of written agreement that's subject to a divorce or legal separation agreement. It doesn't specifically say a judgment. However, there are some people that are concerned that since this is a new law and the IRS hasn't had time to weigh in on it really, that you're taking a chance if you haven't entered your judgment and finalized your divorce by December 31st of 2018. The other school of thought is that as long as you have a written agreement in place by the end of the year, that you might be able to preserve that tax deduction. So when people were in the process of getting divorced, up and through now, as long as we had something in writing that said they're living apart, they're in the process of divorce, legal separation, this is what the support is going to be, and it also has to say it terminates upon the death of either party, then it was tax deductible. So there's two schools of thought. The IRS hasn't weighed in, so to be on the safe side, we're telling people you need to file now and you need to finalize your divorce by December 31st, 2018. The courts are log-jammed, so it takes a long time to get these things through. The court knows this is coming, so they're scheduling walkthrough dates in November and December this year so that judgments that people want to have entered by the end of the year can be done. But all the paperwork has to be submitted, a couple of weeks in advance of those dates. So really, if this is something you're trying to, thinking about doing and you want to be able to preserve that tax deduction, you really need to get filed by the end of this month and then get busy.
What dates are you giving clients to complete the process where the agreement is at least agreed upon, if not filed?
Really, I think people need to have their agreements in place by October so that their attorneys have time to write up the agreement and have it reviewed. The sooner in October, the better, because the walkthrough dates are going to start in the various courts in November. There will only be so many of them. Again, all the paperwork has to be submitted at least 10 days in advance of each walkthrough date, and each court will have a different walkthrough date. So you really have to be planning way in advance to get this stuff done because it just doesn't happen overnight. So you really have to kind of start getting your ducks in a row as quickly as possible. Now, some people don't think this is going to be that big a deal, that it's going to make things easier in certain ways, that there won't be all these look-backs on support, recapture rules, and things like that that we don't really probably need to go into today. But the long and the short of it is that usually you ended up with more income for the family as a whole by having this tax deduction shift from the higher earner to the lower earner. After next year, the support will be taxed at the higher rate, so there will be a lower spousal support payment being made by the payor. And the person will receive less, but what they get, they'll keep. They won't have to pay taxes on it. So it'll make it simpler in that way, but it probably will cost most families anywhere from a few dollars a month to a few $100s a month. So if you think you can benefit from it, talk to a divorce attorney, a certified divorce financial analyst like Mark, or your tax advisor as soon as possible to try to start figuring that out. Now, I know the other question that people keep asking me is, but we want to file joint tax returns for 2018. And do you want to address that? Or do you want me to address that?
Jump right in.
Okay.
I think I know where you're going.
So, yeah, in order to file, even though you're in the process of divorce and you might be living apart, you can still file a joint tax return if you're still married on December 31st, 2018, or December 31st of that tax year. This year, you're stuck with making a choice. If you want to preserve the spousal support deduction, you have to be divorced by December 31st, 2018, which means you can't file a joint tax return. So you need to talk to your tax advisor and have them run the numbers both ways to see which you can benefit from. Now, if you're going to just save a few $100s by filing a joint tax return in 2018, but you're possibly paying support for the next 5, 10, 20 years where you could be saving money with that deduction, then it may be worth giving up filing jointly.
Or you could take the risk.
Or you could take
the risk and not have your agreement done, not file until 2019, and hope that the IRS doesn't have a revenue ruling that comes back and says sorry.
Yes.
You know?
Well, you'd want to file now, have your agreement in place. You could even file your agreement. You just say, don't terminate our status until January 2nd, 2019.
Yeah.
But you do run that risk.
Yeah.
And I wish I could give you guys odds on how I think that might be.
So given that things might have to be finalized by December, people really need to be able to negotiate and get along well enough to negotiate and sort out possibly complicated financial issues or...
I've been telling clients you want your agreement in place by the end of September if you want to be comfortable and not rushed and anxious that this won't go through.
Yeah.
And I may be being a little too conservative, but I'd rather err on that side.
Well, and I would agree with Mark, because I know just last week I had 5 new cases that all wanted to get filed by the end of this month. I don't know how many there might be this week, but then I know that when September, October, November comes around, all those people, not to mention everybody else in the pipeline since the beginning of the year, are all going to want to be wrapping up. So there's going to be a big crunch for everybody involved in the divorce. The parties trying to get everything together at the last minute, the lawyers, the financials that are helping us get all those things together. So really, this year of all years, working well ahead of the game is a good idea.
And that's what I've noticed is there's a lot of cases that have been kind of in limbo that suddenly are waking up and demanding immediate attention. And that's the reason for it.
And do you find people are more willing to compromise because they know this deadline is coming and they need to make some decisions?
It's kind of working both ways.
Yeah.
I mean, it's motivating some people who've kind of been dragging their feet, as Mark said, but it's also putting a lot of pressure on people to make decisions that they may not really be ready to make. And for people going through divorce, as we've talked about, it's a very stressful time. When people are under stress, they don't take in information as well, they don't process it as well. So being forced by the government now to kind of make this decision in on a timeline in a vacuum is just causing some people more stress, and it's making them less able to make a decision. So, there's so many, like Mark said, it's a huge financial transaction to go through divorce. There's so many decisions that need to be made, and adding the added pressure for some people is a lot.
And so this kind of leads into our next topic, which is collaborative divorce, because there is so much pressure and it is such a huge decision to make and so many important things to talk about. Now would be a great time for us to tell our watchers and our listeners about collaborative divorce, what it is, how it could help them in this process. Please tell us your role in collaborative divorce and how it could be helpful to clients, and maybe explain collaborative divorce a little bit.
Okay. So collaborative divorce is one of the options that you have when you're going through divorce, and it's a team approach. So instead of you going out and getting a lawyer and your spouse going out and getting a lawyer and the two parties and the two lawyers kind of going at it in court and asking the judge to intervene in a lot of decisions, you each still have your own lawyer. You each still have a divorce coach, somebody like Lynn, and those people are on your side. Your lawyer and your coach is on your side, and the other person's lawyer and coach is on their side. But everybody agrees to kind of work together in a team approach to come up with the best solutions for this individual family. Then you bring in a couple of neutral people. So financial, like Mark, comes in as a neutral financial who's not on anybody's side. They collect all the information on the finances, they do some reports, and they give the team an idea of how we could divide the assets, how we might deal with support in terms of cash flow for each party, how we divided the retirements. And they can say, if we do it, if we take step A, then this is what it's going to look like in 5, 10, 15 years. If we try tactic B, this is what it's going to look like in 5, 10, 15 years. So they're a neutral. And if you have children, we bring in a child coach, and the child coach works with the parents and the kids, so the kids get a voice in divorce, which is one of the few opportunities they have to do that. And they help the parents kind of really understand where the kids are actually coming from. Are they really worried about moving and being in a new house, or are they worried how dad's going to eat if mom doesn't cook? And so it gives the kids a voice. And again, the child's coach is a neutral person, and they again report back to the team. Now the whole team signs a collaborative divorce agreement that says that we won't go to court. And so there is a disqualification clause in that agreement that says that if the clients drop out of the collaborative approach, that they both have to go get new attorneys and start over. And that's because of some different confidentiality rules and things that are involved in collaborative divorce. And it serves as kind of both the carrot and the stick of keeping people into collaborative divorce. And I do want to say that collaborative divorce is recognized by the courts. There's even a local rule in LA and Orange County and San Diego that deals specifically with people that are going through the collaborative divorce process.
So Mark, as the financial neutral, you would be leading these, sounds like what we call team meetings. You'd be leading the team meetings.
I think of myself as a facilitator.
Yes.
I'm really there as a neutral. My role is working for both of the clients, but I'm also the guardian of the process. That's the way I think about it. So we mentioned before, emotion tends to get high in divorce, and it's very easy for one to become kind of attached to our clients. And if I start to sense that it's becoming adversarial, that we're not being productive, I consider it my role also to identify that and to see how we can address it so that we can be productive. Because one of the challenges is these meetings can get expensive with a number of different professionals, so we want to be extremely organized going in, have agendas. We want to also be in a situation where everyone is prepared, and then we can be extremely productive. And everyone asks the question about cost. How much is this going to cost? All these people billing away at high hourly rates. I always explain to people that the cost of a divorce, first of all, is not just financial. It's also emotional. What's it doing to your ability to work, to be able to function, to be able to earn money? It's a very distracting process, as one who's been through it can attest. Also, I think that when you have a situation where it becomes adversarial, you tend to become defensive and less comfortable in making decisions and more concerned about it. When we can create a safe environment to have difficult conversations, which is what I consider the divorce team to be providing, I think that people come out with better solutions. It tends to be more expensive up front. I call it front-end loaded, as opposed to litigated divorce, which is back-end loaded. I have had so many clients come in and I start to explain what it might cost to do a divorce once I understand their circumstances. And they go, well, I was going to get a litigation attorney and they only wanted $5,000. Well, how does that work, Shawn? That's the down payment.
That gets you about halfway to the first hearing. Maybe.
Exactly.
Yeah.
So again, it can appear to be expensive initially, but because you only have one financial person gathering all the data, not conflicting ones arguing about that, my first role is to gather the data and agree that this is the pie to be divided.
Yes.
And that everyone agrees that this is the pie to be divided, then we can start the process.
And there's a lot of transparency.
Absolutely.
In the process. No one's trying to keep secrets. No one's trying to get leverage over someone else. And in collaborative divorce cases, you might be thinking, Shawn, as an attorney, what does the other side need? And they might be thinking, what does your client need to get through the process?
Yeah, as opposed to the adversarial process of litigation, where somebody's trying to win and thereby make the other person lose on any given issue, whether it's custody of the kids or whether they play soccer or not, or dividing the pie. In collaborative, we're really all trying to work together to come up with the best set of solutions for this individual family. And the parties, the husband and the wife, or the two spouses, they have a lot of input into what they need to have happen, what they each kind of need for their living situation. You know, what are their kids like? We don't know their kids. They know their kids. And with the help of the child coach, they can come up with a parenting plan that works for their kids instead of some kind of cookie cutter plan that they get out of a book somewhere. So, you know, it really does allow for a lot of individual problem solving and team cooperation. There's the agreement provides that there's no secrets between the attorneys, so nobody plays hide the ball, one of the reasons for the disqualification clause. So if I know something that's important, I need to be able to share that with the other attorney. So it's a very open, transparent process that allows people to come up with, you know, the best solution possible for their family.
And that flexibility is critical, I think, because although family law judges have probably more latitude than any other form of law, I suspect, they still have to follow the rules. So when you get into a situation where there's an argument about, is this a marital asset or is this separate property, they would have to come down on one side or the other, whereas we can negotiate something that might be a little more flexible than that if one side has a stronger argument than the other.
And we've got another great question from Carol. She says, I'm interested in collaborative divorce, but not sure if my soon-to-be ex is on board. Any advice to get him on board? What's been your experience with, you've got a client, she's interested in collaborative divorce, this is going to work for her. How do we reach out to the soon-to-be ex-spouse and tell them about collaborative divorce?
Well, the first thing would be to try and get them to divorce options on the first Saturday of every month.
Yes.
So that's always a great place to start. And I've had cases where somebody's called up and said, hey, I've heard about collaborative divorce. And I say, hey, next month on the first Saturday, why don't you both go to this divorce options class? Because that's one of the things that we do talk about. The other thing is to try, and I send my clients a letter that basically explains the difference between litigation, mediation, and collaborative divorce, so that they can then share that information with their spouse, and then hopefully invite them to a divorce options class or to some kind of meeting with an attorney who's willing to sit down and explain to them what those same kind of options look like. What have you done, Mark?
It's easier for me because I'm a neutral, so I can talk to both spouses. And when a client calls me and they're interested in this process, I say, and clients always want answers. They've got burning questions. What happens about the house? Do I get the house right? Or, I mean, my pension's mine, isn't it?
Yes.
You know, that kind of stuff. I push back on that and I say, got to decide how you're doing it first. And if we're considering alternative dispute resolution and particularly collaborative divorce, I would prefer to sit down with them both together, so they hear everything at the same time from me. Because one of the things that happens in divorce is, if you find me, I am now tarnished with your spouse because I must be on your side because you want to work with me. So I always push back on that and make sure that my neutrality is not compromised and that I have the opportunity to speak with both people, and they can hear exactly, and they can hear their own questions answered and what their spouse got to hear.
Yes, yes. And for me as a therapist, I will get clients that really, really just want to keep things out of court. They want to stay in charge of the decision-making process, and that's why collaborative really works. They're negotiating, they're leading. It's a client-centered process, and that's what works best for them and their family.
And it allows them a little bit more control.
Yes.
Because they can set when the meetings are going to be. If you have a court date, you need to be there. You know, whether that's convenient family-wise, whether that's convenient in terms of your work schedule, courts don't mind. You need to be there. And whereas we can schedule things at times that are convenient and that work for the family.
And I'd say that's a really common question that I get from people all the time when they call my office, whether they're calling about mediation or collaborative divorce, is they want to know, does this mean they don't have to go to court? And generally speaking, yes. I mean, we do have these court resolution conferences that are set in San Diego when you're going through a divorce, but 9 times out of 10, if you elect an alternative dispute resolution process for your divorce, mediation or collaborative divorce, people will never have to go to court. We have to send forms and documents and agreements to court, but not people. And like Mark said, if you're in court and you're asking the judge to make decisions about your money, your kids, your house, because you haven't been able to come up with an agreement, then the judge has to follow the law. And so they will make a decision that it's possible that neither party will like. And when you choose an alternative dispute resolution process like mediation, like collaborative divorce, then the clients are in control of those decisions.
So why don't we tell our viewers and clients how they can get in touch with us? Shawn, if people want more information from a family law attorney, how do they find you?
They can call me at 619-299-4880, or they can go to my website, ShawnSkillinLaw.com.
And Mark?
My phone number, I'm in the Del Mar area. My phone number is 858-509-2320, and you can check out my website at pacdivorce.com, PACDIVORCE.com.
And people can find me on my website, which is lynnwaldman.lcsw.com, or give me a phone call, 619-865-3203. And we want to remind the viewers of our Divorce Options Workshop. Again, it's
going to be July 7th. It's from 9 to noon in Carmel Valley. The address is 11622 El Camino Real, Suite 100. They can call at 858-472-4022, or go on our website online, which is the collaborativefamilylawsandiego.com, and click on the link to the Divorce Options Workshop, which is in the navigation bar at the top of the page.
And I want to point out too, it's for same-sex couples as well as for married couples. It's for domestic partners too. This is valuable information for everybody who is going through really the end of a personal relationship. I've always said that the courts are the worst place to end a personal relationship. It's awful.
Yes.
Can I give one quote?
Sure.
I like to read, and there's a guy called Scott Turow who writes beautiful legal thrillers.
All kinds of legal books.
Yeah. Presumed Innocent was the big movie that one of his books was. In his most recent book, the protagonist is going through a divorce, and at one point he said, "He/she doesn't love me anymore. That was an injustice for which the law had no soothing response." And I think that captures perfectly why the three of us sitting at this table are so committed to trying to work in alternative dispute resolution.
Yes, yes, that's a great quote. Yes. And again, one of the important things for folks to remember is once you have decided to divorce, how is going to make the big difference, how you decide to go about it.
And you do have alternatives. I think a lot of people don't know that they don't have alternatives. They think they have to go get a lawyer, they have to go to court, and you don't. There are choices, so come to a divorce options class and we'll help you figure out which one works for you.
And the problem is that once you get on that, I call it the divorce escalator. And by the way, it doesn't go up, it goes down. If you've ever tried to get off an escalator going the wrong way, you know how difficult it is. So if you have any ongoing relationship with your soon-to-be ex, and you can talk about things and you can discuss how to do it before one of you goes out and gets that shark attorney, it will be to your benefit, I promise you.
Absolutely, absolutely. And we also say in divorce options that divorce is very common. We hear 60% of the population might be divorcing. But for you, it's not common. You know, for that family, for that couple, it's not common. And we hear about it all the time, and it's overwhelming. So we also like you to think about what story do you want to be able to tell about how you divorced. So,
and what story will your children tell about your divorce? Because this is something that affects people late in life. In my other career, I have a financial advisory practice, and for many years I had a client, very successful woman, late 30s, early 40s, and would come to our client dinners and always bring the same boyfriend. And I said, I knew her very well, and I felt intrusive enough to say to her, well, are you guys ever going to get married? And her response to me was, I would like to get married, but if I have a wedding and invite my mother, my father won't come. And if I invite my father, my mother won't come. So I just can't face it. And they were divorced nearly 30 years prior.
Yes, yes.
So the damage that can be done through an adversarial process or a divorce that goes off the rails has impact not just on the couple, but also on everyone surrounding. Grandparents, So the more you can do it in a way that actually allows you to achieve your goals and perhaps allow your spouse to get some of their goals met too, is going to be beneficial.
Absolutely, and avoid that long-lasting, unnecessary trauma to the whole family and damage. Yes, yes. All right, so last word, Divorce Options Workshop, the first Saturday of every month from 9 to noon in Carmel Valley, right next to the Ruth Chris Steakhouse. And you will find that at collaborativefamilylawsandiego.com. There's a tab you can click on for more information. Last comments?
Pleasure to have been on today, and we look forward to speaking with you next month and the month after.
Thanks to Carol and Rachel for the live questions, and we'll see you next month on July 17th.
July 17th at 1 p.m. See you then. Thank you. Thanks, everyone.
Thanks, Lynn.